One of the things I commonly hear when I meet clients for the first time is their misconceptions about the law. So I've decided to put together a list of the top 5 misconceptions about the law. Number 1, I don't have a record until I'm convicted. That is patently untrue. From the time you are arrested, a record is created. No matter if your case goes anywhere, if you're charged, if the case is dismissed, you will have a record. And the way that record works is the police department that arrests you will send that record to the Texas Department of Public Safety, or DPS. DPS collects all and maintains all criminal records in the state of Texas. Why is that important to you? Well, if you're applying for a job, if you already have a job, if you're trying to get a promotion, they will run a background check on you, most likely. Either the company you work for or a third party that they hire will contact DPS. DPS will search your information either under your date of birth or your driver's license or your first name and last name. If you have, say, arrest for DWI, driving while intoxicated, or an assault arrest, or anything else, anything above a Class B misdemeanor in the state of Texas, that information will be forwarded to that third party or to your employer, and they'll know that you are arrested for instance, a DWI. And it doesn't matter if that DWI was dismissed, if the case never went anywhere, there will always be a record of that case as soon as you are arrested. Number 2, the police did not read me my Miranda rights when I was arrested, so it's an illegal arrest. This is also not true. The police do not have to read you your Miranda rights until you are officially detained or arrested. And when I say detained, that means that you're either in a room where you're surrounded by cops and you don't feel like you can leave, or they've put handcuffs on you. And only at that moment do they have to read you your rights. And a police officer, again, does not have to tell you those rights. For instance, when they stop you, they can stop you on the street. And if they stop you on the street, initially, I would give you the advice of saying, well, I don't have anything to say, and you move on. If they tell you you can't leave, you are detained. Then at that point, it's pretty safe to assume that they do have to read you your Miranda rights. Number 3, I don't have to tell the police anything if I'm stopped illegally, or how you would define being stopped illegally. That's initially true. So if you're walking down the street and the police want to talk to you, you can tell them no. You don't have anything to say to them. In fact, I would tell you most of the time that's what you want to tell them. If at that point, however, they tell you you have to stay and talk to them and they ask you for your driver's license, if you haven't, or another form of ID, you have to provide that to them. And you can't provide them a false name, a false address, or a false date of birth, because at that point, you're committing a crime. You're committing a Class B misdemeanor. So never do that. It's always best to be polite with the police. You have to properly identify yourself. You have to give them identification. But after that, you can politely refuse to do anything they want you to do. Number 4, I want to hire an attorney to file charges against someone. This is technically true. You can hire a firm and you can hire me at Varghese Summersett to investigate if you believe you've been wronged in some way. However, I can't file charges on your behalf. You can't file charges on your behalf. You have to call either your local sheriff's office or your local police department if you've been, for instance, assaulted, and report that crime to them. At that point, the police department, not you, not your attorney, they will decide whether or not to file those charges with the DA. And in Tarrant County and in Dallas County, there's an elected DA. And the police department, whether it's the Dallas Police Department, the Carrollton Police Department, the Fort Worth Police Department, based on the information you give them, will decide whether or not to file charges against the alleged person that you said has injured you, for instance, in an assault. And if they decide to file charges, they submit that to the DA. The DA then makes a second decision after the police have already made their decision about whether they're going to accept those charges. And for instance, in a misdemeanor, if they accept those charges, then the person that you said assaulted you will be charged with the crime of assault. But there's nothing that you can come to a lawyer to. You can't pay me money to file charges against someone else. And you can't tell the police or the DA that you want to file charges and then charges are automatically filed against someone. You can report your offense, and we encourage you to do that. If you think you've been injured, we can help you do that, and we can give you the information necessary you need to properly report a crime. However, you need to understand that once you report it, it's not up to you about whether charges are filed or not. It's up to the police department or the elected DA. Number 5, I can't be charged with a crime unless the alleged victim decides to press charges against me. Well, that's also a misconception. It's ultimately up to the prosecutor whether or not to pursue charges against you. Just like you have the right to take your case to trial if you're charged with a crime, a prosecutor in the state of Texas has the right to take something all the way to trial. They never even have to make you an offer for probation or another offer that you might agree to. The best example of this most recently, and I know we've seen it ad nauseum, but it's a great example about pressing charges. You may have read in the press after we all saw Will Smith slap Chris Rock in the face at the Academy Awards that Chris Rock decided that he did not want to press charges. It's completely irrelevant. And even though that happened in California, the California law is the same as Texas law. The prosecutor can evaluate that case on its own terms. And in there, it was on video for everyone to see. Will Smith walked on stage, slapped Chris Rock in the face. He obviously felt pain. That's an assault. So it doesn't matter what Chris Rock wants to do or not. If a prosecutor sees that or if a police sees that, they can decide at that point to file charges against Will Smith for assault. If you have any questions about the law that you would like answered, please leave a comment below. Or you can call us at Varghese Summersett, and our phone number is 817-203-2220.